Good morning. I would like to welcome all the attendees who have joined us remotely. On behalf of the commissioners, I would like to welcome you, the commissioners of the INAH. I would like to thank you for your participation in the 43rd Global Privacy Assembly that this year has as a subject privacy data inclusion, a human being-centric approach in this international forum with specialists and authorities from different parts of the world. We are discussing quite relevant topics in a coordinated fashion with the purpose of adding our efforts to guarantee the fundamental right to data protection of all the people globally. In that sense, the topic of this specific session is of inclusive policies linking poverty and marginalization sectors in the protection of personal data. As we all know, information technology and communications offer great advantages for the population as greater access to information. However, these digital benefits are not having an equal impact to all social sectors. There is a clear imbalance that we know as digital gap today, which is the result, even more so, of things like the sanitary emergency that we are facing. This identified the importance that having access to internet has in order to be able to fulfill social needs, including work and education. However, according to the International Union of Telecommunications, specialized agency of the United Nations, around 3,600 million people do not have access to internet, accounting for almost half of the population. We shall say that this difference obviously is expressed more profoundly in some regions. For example, in the case of Africa, a large number of the inhabitants do not have access to the internet. 87.2 in Europe do have access to internet, or 94.6% do have access to internet in the United States. In the case of Mexico, 70% of the population has access to internet. Therefore, 30% of the Mexican population is still not having access to the internet. Therefore, what we shall discuss in this table is of utmost importance to be able to know which are the inclusive policies that we can put on the table and develop in order to incorporate all these sectors of poverty and marginalization, because the word marginalization implies that they are outside their due exercise of rights, as in this case, that of protection to personal data. Therefore, it is very important that the different nations may develop policies in order to include these sectors. I would like to give an example, and then I will give the floor to our distinguished guests. And at the IDAI, we have developed some mechanisms so that people may have access to data protection, such as a platform that allows one to make ARCO and portability requests, but this is for the public sector through the internet. But recently, for the last month, we have had the possibility that for those people who do not have access to the internet, we have opened a call center where people just with a phone call that can be made by anyone. Any person can make this phone call because we're not needing intelligent telephones, but the traditional phone, they can make a free call from any type of telephone from any part of the country. And we can capture their request of ARCO rights. For the public sector, it would also be good to apply them as well as to the private sector and concentrate their reports for inadequate use in the treatment of personal information, either by the public sector or the private sector. Well, let's start now with the introduction of the members of this panel. I would like to welcome Gianclaudio Malgieri. He's Associate Professor of Law and Technology at the Augmented Law Institute located at Lille, France. He is a member of the Privacy Center in Brussels. He is member of the Editorial Council for Law, Computer Law and Security Review. And he is an external expert at the European Commission, at the Executive Research Agency. He has performed different types of research, and he teaches on data protection law, privacy regulations, digital consumer protection law in the digital market, sustainability of data, intellectual property law, and he has more than 50 publications quoted by different authorities and main newspaper publications globally. He has received a lot of decorations, and I would now like to give the floor to Gianclaudio. Gianclaudio, you have the floor now.
Hello everyone. Can you hear me? ¿Me puedes escuchar? Hola, voy a hablar en inglés. I'm going to talk in English. So, basically, I'm extremely happy to be here. So thank you very much for this introduction and to be with this great set of panelists. About the topic of today, I will just launch a few provocations, and I hope my fellow panelists will develop them. Basically, I think the topic of vulnerability of data subjects in the GDPR and the data protection law under a more global perspective is quite an urgent topic that has not been addressed so far. So I'm extremely happy about this initiative, about this panel, and more panels will come in the future, I hope, and papers and studies. I think that people, as the commissioner was saying, there are people with limited access to internet, but also people with limited access to, let's say, information related to their data protection, and also with limited cognitive capabilities to understand them. So just an initial maybe definition of people in disadvantaged situations and data protection might be to distinguish between people that have problems in understanding privacy policies, in exercising their data protection rights. I was hearing the commissioner saying that in Mexico now there is a call center helping people to exercise their data protection rights. This is incredibly helpful, and it helps the first kind of vulnerability, which is a vulnerability related to information data processing within the data processing. And then there is another kind of vulnerability that I would like to address, which is also vulnerability about the effects of data processing. So vulnerability to discrimination, to manipulation, to stigmatization, and to other harmful effects. This is a different kind of vulnerability. We cannot just solve these with more accessible transparency and more accessible, let's say, data protection rights. We should do something to address also these kinds of vulnerability. And I think that it is, in this regard, it's important to consider ex-ante safeguards. For example, fairness principle in different legal systems. In the GDPR, we have fairness as a strong concept, but still we need to understand how it is implemented. Then we have other important safeguards. For example, in the age of AI, we know how important it is to limit discrimination of vulnerable people online, right? And or even manipulation. We usually mention children among the vulnerable people, but this panel is addressing more poverty and social and economic disadvantage. Well, I think that in the GDPR, there's not so much pressure. So in Europe, in the European Union, we don't have very much attention of the problem of data protection related to poverty and social disadvantage. I think maybe just one thing could be emphasized. I would like to launch this provocation to my fellow panelists, and is the double privacy paradox. There are people, in particular what I call vulnerable people, that is a big and ambiguous category, but we can at least put in this category, let's say, all people, all data subjects with higher risk to their fundamental rights and freedoms. Well, we all data subjects have a form of privacy paradox, right? So we apparently don't want to share our personal data, but at the same time we do, for some remunerations, which is, let's say, formal or informal. Well, vulnerable people have a double privacy paradox, I can say, because vulnerable people, so people with higher risk of adverse effects to their fundamental rights and freedoms when their data are processed, like, as we said, people in social disadvantaged situations, but also children, also elderly people, also disabled people, etc., and LGBTQ minorities. Well, these people have, first of all, more concerns to share their data, because this data could be source of discrimination, could be source of adverse effects, right? But very often these people have higher needs to share their data. Even though they have concern, they have higher needs to share them. Let's get the example of ill people during COVID. They really need that their data are processed, even though they know that this data might be sources of discrimination. Another example is for disadvantaged people, like for in situation of poverty, etc. Of course, it can be source of strong discrimination online and offline, but still they need their data to be processed, because the social systems are usually based on algorithms that allow social welfare to work, right? And many great scholars, especially in the US, have emphasized this exploitation of data poverty, we can say. So of exploitation of vulnerable people with their personal data. I don't want to monopolize today, so I think I just launched some provocations. We could talk a lot about this. I hope there will be occasion to do another round. So it's all for now. Thank you. I don't want to monopolize today, so I think I just some provocations. We could talk a lot about this. I hope there will be
vulnerabilidad, y que estas se pueden deber a limitantes a acceder no solamente al Internet, que es una, porque al mismo tiempo es la forma de hacerse de información para poder proteger su...
So that you can then protect your data. But there is, in addition, another type of non-access, such as the lack of knowledge that you have a right to protect your data. That's another vulnerability. Obviously, this it links us to the people who are in situation of poverty or marginalization. They might be vulnerable because of the social and economic situation, but even more vulnerable than any other person when we talk about the treatment of their personal data, given the fact not only that they don't have the necessary knowledge, but also that those people must deliver their information to be processed in order to have access to basic services that are provided by the state, such as health or welfare in case of unemployment, for example, or fight poverty through direct aid to the people. Now, let us give the floor to the next member of this panel. She is Valeria Milanés. She's Executive Director of the Association for Civil Rights in Argentina, and she represents this consortium. She is an expert in information technology and data protection, and a lawyer with experience in different types of litigation. As part of this association, she has coordinated several national and international reports on data protection systems, as well as several other aspects. She has challenged at court the technologies implemented by the state. As part of her association, she has participated in several international fora, such as the Red Iberoamericana de Protección de Datos and the Committee on Economic Digital Policy of the OECD. So we would like to give the floor to her now. Valeria Milanés, you have the floor. Thank you very much, Óscar.
In English. First of all, thank you for the invitation to participate in this panel, to the authorities of the GPA and the INAI for the organization of this event in such challenging conditions. I would also like the joy of sharing this space with such distinguished colleagues. As part of our work in ADC on technology and fundamental rights, we have analyzed diverse phenomena, and we have progressed from a first stage of general understanding of these phenomena and technologies to a second stage of particular understanding of how technology affects groups in vulnerable situations, such as people with disabilities, LGBTQ people, women, children, and adolescents. This journey has allowed us to verify that when we are in front of groups in vulnerable situations, we cannot think about the technological issue, and in this case, the issue of personal data of poor and marginalized sectors, without understanding the context in which this situation is generated and developed, considering both intersectional and structural aspects. In this sense, I will emphasize aspects that characterize poverty and structural inequality in Latin America and the Caribbean, which have been studied for a long time, and which are very well reflected in the Regional Human Development Report 2021, published in June this year, prepared by the United Nations Development Programme, entitled Trapped, High Inequality and Low Growth in Latin America and the Caribbean. The report characterizes one of the most unequal and violent regions of the world, deepened in its manifestations the pandemic. The report refers to three reasons for the high inequality and low growth, which interact among them and have been perpetuating for years, because this is not new. One, the concentration of power. Two, violence in all its forms, political, criminal, and social. Three, social protection systems that do not work so well. I will focus on the concentration of economic and political power, which means the concentration of power in the hands of a few companies who defend the private interests on interest. The report recognizes monopoly power and corporate political power as two sides of the same coin, since monopoly rents translate into political power, which in turn increases monopoly power, creating a vicious circle. Latin American markets tend to be dominated by a small number of giant companies, providing, among others, media services, cell phone services, internet services, microfinance services, among others. I highlight the huge amount of personal data originated from the user services. The political power of these firms distorts political power beyond the market level, including, for example, fiscal distortions, as the report also highlights. As a consequence of the above, the report also reflects on the ineffectiveness of competition laws and agencies, which lack the necessary powers to investigate, to contain cartelization through adequate fines or sanctions, adding that most of these offices are understaffed in terms of quantity and expertise of their staff. It should be added that the report's description to the characteristics of competition authorities also applies to most of the personal data protection authorities in the region. And why do I bring these highlights to this panel? The Latin American and Caribbean region has many challenges in terms of the adoption of high standard personal data protection regulations, and in terms of implementation and enforcement of those regulations. And everything remains to be done in terms of effective protection of personal data of people's liberty and marginalization, for whom there are no differentiated protections as far as I know, but for which there are social aid policies, short-term and palliative of the situation of poverty, not overcoming it, for which all personal data, in many cases sensitive data, must be given indefectively to governments. We cannot think how to settle this enormous debt in the personal data protection systems at local and regional level, nor begin to think how best to protect the personal data of people living in poverty and marginalization without considering from the very outset issues of competition and the concentration of political and economic power that are so deeply rooted in this region and have so negative effects in their consequences to tackle inequality. I am aware of the particular interest of the Global Privacy Assembly has in fostering conversations between data protection and competition authorities, as global technology and data monopolies require it. Like, to illustrate very, very briefly, the Latin American and Caribbean region also requires a different but necessary reading of this phenomenon of interaction between competition protection and personal data protection. We from civil society, we will do our best to push these conversations to better understand these interactions and their consequences, and hopefully promote proper actions, most in benefit of these sectors that live in poverty and are marginalized. Thank you very much.
Bien, muchas gracias, Valeria. Y bueno, pues
Thank you very much, Valeria. And as you have mentioned, in Latin America and the Caribbean, this is a situation that affects poor or vulnerable sectors, and therefore it becomes more acute, and therefore we have to take into account the ethical and economic power. This is kind of a society that has little social development, and due to stagnation and due to inequality, we see that there has been a sanitary thesis, and here we need to see all the vulnerable sectors we have in Latin America and in the Caribbean. For instance, in very many countries of our region, Latin America namely, there are no standards yet, preliminary standards in order to protect personal information. We do not even have the regulation or regulatory framework so that this right will be implemented. In some cases, well, this becomes judicialized, but obviously the most vulnerable or the poorest sectors do not have access to be able to judicialize any problem that might appear. Obviously, the challenge in those countries where marginalization or underprivileged situations and poverty, the challenge is twice as much, and state policies from the standards, regulation, and policies can really level off those most vulnerable sectors, because we cannot try every sector as alike. But now we are going to go to give the floor the next speaker. I hope I will be able to pronounce her name correctly, Fredesvinda Montes. She is an attorney at law at the Complutense University, and she's a graduate student of political sciences in distance education. She has a master's degree in data protection and new technologies, and she studied at the Antwerp University, where she studied comparative law. At present, she's a specialist at the World Bank in the financial sector, and she has really proven to perform this type of works, and she has participated extensively in the financial sector in over 40 countries all over the world. As a representative of the World Bank, she develops topics that include consumer protection, privacy and data protection, cyber security, and the institutional financial framework, as well as its surveillance tools. At present, she co-chairs the technical committee as to cybersecurity and the financial infrastructure, and the technical committee in digital aspects of all this integration. Then we will give the floor to Mrs. Montes.
Good evening, wherever you are, fellow panelists and distinguished members of the Global Privacy Assembly and experts connected everywhere. I want to thank INAI for inviting me to this panel, which is very much linked to the objective of the World Bank of poverty alleviation, shared prosperity, and economic growth. Personal information from vulnerable population is effectively processed by public entities and by private sector entities too. This data processing, as we have seen, does bring a lot of new opportunities and benefits for these groups, but it could also lead to harms that might involve also excluding them unfairly from opportunities, like in the case that we have been studied significantly access to credit, or also being unfairly targeted for on based on determinations made by artificial intelligence or scoring models. In addition to this situation of the vulnerable population, the lack of specific privacy protective measures for these communities makes them be more vulnerable to privacy risks. The perspective that I'm bringing to this panel today is the financial sector agenda and the links with data protection and the work that the World Bank has been doing in this space since 2002. So why do we care at the World Bank about data protection? Where our goal at financial sector and in my unit, financial inclusion, is to bring more individuals to access financial services. To do this, we do need to create some or build trust in the financial sector. And there is a need to share information, mostly personal information about individuals, to enable these individuals to access financial services. So this type of individuals in particular, we are worried and we are concerned about the unserved and the underserved. And in this group of people, going back to the definition of a vulnerable population, we include women, youth, migrants, and this can be considered vulnerable population. So and indigenous people, sorry. Since 2002, a great part of the work that the World Bank has developed evolved around balancing trade information sharing and data protection, which resulted in the World Bank issuing through the ICCR, the International Committee on Trade Reporting, the general principles for trade reporting. They include 5 principles on trade reporting. 4 of them relate to data protection, including data quality, security, consumer rights, and cross-border data flows. Moreover, when the digital financial services made its way, it was clear that additional data sharing was going to take place, and the World Bank again stepped in 2017 and developed some guidance on data protection under the good practices for financial consumer protection. In addition to that, we partnered with the G20, the Financial Inclusion Partnership for the Financial Inclusion Partnership of the G20, and with them we developed some work, including brief policy briefs and research studies on the use of alternative data and data protection for the evaluation of creditworthiness. Again, resulted in a publication dealing with these particular aspects. With the Financial Action Task Force, the FATF, and also on their some of the objectives of the FATF, we developed the digital identity guidance in partnership also with the ID4D group within the World Bank. This also includes the linkages on data protection when dealing with or developing digital ID systems that include the collection of very sensitive data, including biometric data, with the objective of enabling additional individuals to access or open accounts in a more effective manner. In this sense, we also partner with the FSB and with other authorities in developing cross-border payments and enabling them to have a roadmap to a more efficient cross-border payments agenda. There are 2 building blocks under this roadmap, one that relates to the data frameworks and the other one that relates to the digital ID, which both touch upon data protection frameworks. So on and all, and the additional work that we conduct at country level, at the World Bank, we do develop a very specific and deep analysis at country level of the specific aspects that in the financial sector, driving from moving forward the financial sector agenda, have to take into consideration the need for protecting individuals, and in particular, those that are unserved and underserved. So I'm happy to participate in this panel and look forward to that discussion. Thank you.
very much. Well, we have the representative of the World Bank, and she has told us about how the bank works in this financial sector with vulnerable sectors, so women, Indian people, indigenous people, but this financial situation is taking as a parameter the participation of these people and developing different digital guidelines for people through its information, biometric information can really facilitate these transactions, but at the same time have all the mechanisms as to the security that has been given to their personal information. We do think that this is an important policy implemented by the World Bank, and we would like to extend it to all the region and to the financial institutions. Well, now I'm going to give the floor to our next speaker, who is Malvika Ragevan. She is the main researcher. She is from India, and she will tell us about the importance of privacy. She's an attorney at law, and is a graduate student from Harvard in public policies, and she analyzes the life of people, of low-income people in India. At present, she's working at the School of Economics in London and in management systems, and she founded the Initiative for Finance in an Indian institution in 2020. And her work, she was able to see how technology could help finances. Her researchers were together with the project. So at this time, we will give the floor to our next speaker, Mrs. Raghavan. Thank you. This tech problem, we can give you Dr. Gabriela Fortuna. She's an attorney at law and privacy of global privacy at the Forum of Future privacy, where she's a consultant on the law and protection privacy laws.
Referencia a la Asamblea.
She's right now member of the panel, and she's also member of the executive committee of the Conference on Equity and Transparency and Accountability. She is part of the Observatory on Digital Media in Europe. She has worked in the creation of code of conduct on the access to data at the platform of the regulations of the European Union. With regard to right to privacy, Gabriela testified recently for the Federal Commission of Trade in the United States on data portability and for the Committee of the European Parliament on the proposal of the governance law for the European Union. She has worked in multiple important projects with several international authorities, being part of several committees, a researcher and author of several specialized articles on data protection. Gabriela Zanfir, you have the floor now, please.
Commissioner, for such a lovely introduction. Thank you to my panelists for sharing their thoughts, and hopefully the technical part works now. Thank you to the host for hosting this great Global Privacy Assembly conference. I wish we were all in person in Mexico City. But maybe with another occasion, we will be very happy to join you in Mexico. On the topic of our panel today, respectively thinking about policies of inclusion and vulnerable populations and how does this report to data protection law, I would say perhaps the question to ask is whether data protection law has a role in promoting inclusive policies. And from my point of view, the answer is absolutely yes. The first point I wanted to send across is that perhaps a little known fact to those who have not spent years researching the history of data protection law around the world is that at the very beginning, in the 60s and the 70s, when lawmakers in Europe were thinking hard on how to provide legal protection to their constituents in the face of new capabilities to electronically collect, store, and process personal information, one of the key concerns was managing fairly the welfare state. How to make sure that new social protection benefits for the population are accurately tracked and distributed. How can transparency and fairness be ensured? How can individuals have some control over the accuracy of their data? Should they be able to ask for correction of their personal information or erasure of their information? So dealing with these types of questions actually led to the first data protection laws in history. It's no coincidence that the first general data protection law adopted by the German land of Hesse in 1970 was only applicable to public bodies, right, including the public administration. So data protection law as a field came into existence also to provide an answer to concerns about transparent and fair distribution of benefits across the population of a welfare state, among other foundational reasons, of course. So data protection law and promoting inclusive policies are inextricably linked from my point of view. Of course, in this day and age, the problems are much more complex, but data protection law also is evolving, and it continues to constantly evolve in order to tackle the more and more complex problems raised by automatically processing of personal data. Now, the other point I wanted to send across for this debate, and this is also something that my co-panelist Gianclaudio Malgieri mentioned at the beginning, is the issue of fairness. And frankly, it's not an issue, but it's a core concept at the heart of data protection law that I believe has not been sufficiently understood, has not been explored, has not been applied in practice as much as it should be applied in practice. This is a foundational principle of data protection law as we have it built in Europe, but not only. Only think about the fact that one of the first data protection laws here in the United States, where I am currently present, was the Fair Credit Reporting Act. So fairness in how personal data is being treated and it's being processed has always been at the core of this entire field. And I think that in promoting inclusive policies, it will play a very important role, but we just need to learn how to unpack it and how to unleash it on some of the facts of reality that are happening right now. To just give you an example, only last summer, we have seen what was happening with students that graduated high school in the UK, and also students that graduated high school in their international baccalaureate diploma, dealing with the fact that they believed, and apparently for right reasons, it was unfair for the exam that evaluated their end of high school efforts to be actually automated and to take into account historical data from the previous graduates in the high schools they were attending in order to establish their automated final exam grade. Right. So that was an exceptional situation that happened because of the pandemic, where students were not able to actually participate in an actual individual exam. And a decision was taken in these two different scenarios in the UK and then separately by the International Baccalaureate organizers to automate the grades that high school graduates would have. And as you know, actually we have seen, those decisions were taken back by the organizers. At least in the UK, we know that those grades that were fully automated were actually not followed through in the end. And then we also have seen at least a draft decision of the Norwegian DPA with regard to the International Baccalaureate exam, sanctioning the organizers of the exam for automating the evaluations to actually challenging the fairness of how that processing of personal data occurred. Because in the end, what came across was that individuals who were actually attending schools in poorer districts or in poorer area codes were actually sanctioned because of the past performance of their peers, which was deemed to not comply with the fairness principles. Norwegian Data Protection Authority when looking at the IB situation in their preliminary decision. So fairness is absolutely at the core of the debates we're having right now, and it's at the core of data protection law generally. And I think, as a matter of fact, data protection law with principles like fairness and transparency plays a crucial role in ensuring inclusive policies are seen through completion. And it can help bringing marginalized populations fairness and non-discriminations in the way we are treating personal data as a society. So those would be my initial remarks, and I'm looking forward to the debate.
Thank you. Thank you very much, Gabriela. Let us check if we have the audio now for Malavika. Malavika, could you test your microphone, please, if you are so kind? Thank you so much. It's wonderful now. Thank you.
Thank you for inviting me and for all of you for bearing with these tech problems that we've been having. If you can hear me now, I'm happy to make my comments quickly and then turn the floor back to the Commissioner. Great. Thank you, Commissioner, and thank you to all the panelists and everyone listening. First of all, I'm lucky that I could go last because I'm hoping to pick up on some of the things that all of the panelists have said. My own background is in India, where for the last about 5 or 7 years, actually, that I've been looking at this intersection of um, people who are low income and particularly marginalized in society trying to access services, especially finance. And a large part of my job, though it began there, started engaging with how more and more people in India and similar contexts actually remain in poverty but start accessing digital services. And one thing that has come out of that research, which I think plays with what Claudio came up with in the beginning and Gabriela mentioned again, is this idea of fairness. And the reason it's important, I think, is because of two separate limbs, which I'm hoping to just go through in my opening comments. The first limb is that people are now experiencing poverty and going through a process of marginalization within a digital system. So I think until a few years ago, the proponents of digital systems often framed as a trade-off. The idea was that once people had access to digital financial services or a digital identity system, then privacy could be somewhat traded off in that context. You first get access, and then you can build in privacy, right? That was the general framing. The idea was that there is almost a hierarchy of needs, and privacy is not as perhaps important for poor people as it is for others who are already well embedded in digital systems. I think what the experience of the last couple of decades has shown is that if privacy isn't tackled alongside this idea of access, if the quality and the quantity of access is not provided with privacy, that can have some very far reaching effects in terms of basically entrenching the power structures that already exist in society. To give you an example of what I mean from that, I'm going to draw from a few field studies that I've been a part of. The first set of examples I'll give you will be to really illustrate how the absence of privacy can marginalize people within digital systems. So these are people who might have access to the internet through mobile phones, through otherwise, and to government systems which are digitized, but the absence of privacy can affect them. And then you have a different kind of marginalization, which is at the boundary, where their inability to access that system or be recorded by that system also causes some kinds of harms. I think why this is important to talk about in every context, European, Anglo-Saxon, Global South, whatever you talk about. And I think is that what happens is that your traditional axes of marginalization, whether that's gender, in India, caste, class, race, religion, political affiliation, etc., also start playing out online. And what I mean about this, very practically speaking, is that we find in India, for example, that we have over 1 billion people and over 1 billion mobile phone subscriptions, and 98% of people in India access the internet and digital services through mobile internet, not through broadband. This is a well-known fact. In practice, what you will find is that often the ownership of mobile phones is gendered. Also, it varies by income group, and it varies urban and rural. So in urban India, you will often find people having 1 or 2 or 3 mobile phones, whereas in rural India, the tele-density is much lower. And what you find is that often a family will share a mobile phone, or a group of people will share a mobile phone. And in that context, all of your marginalization factors play out. For instance, women will generally access a mobile phone in marginal communities, or especially where they have more of a sort of a less income capacity, they will access it through a male member of the household. And this has several consequences for policymakers when you're thinking about designing privacy laws and designing for core concepts like what does consent mean, what does purpose limitation mean, right? because I think one of the important things to think about if we really care about marginalization and protecting the privacy of individuals is to think about how can we recraft these principles or extend them in the context of this kind of mediated or assisted use, which is the norm for many marginalized people in the world. When you're talking about government social assistance programs, most low-income people will be going to an official, will be going to someone else who will then navigate the digital sphere, who will assist them to do so. And of course, you hope that they will be good officials or good intermediaries, but there's always a chance that that's where the data protection loss can really harm that individual. I think the solution to this is to really think about what would be a reasonable expectation of privacy for an individual. We have good legal concepts already in terms of what reasonable expectations are, what they should be, and you don't have to always ask for consent. I think the idea is how do you create a safe environment for vulnerable people to interact in and to get security when they are accessing services. And I can talk more about this if we get a chance in the conversation. But very quickly, the other type of marginalization I wanted to talk about is something that Fredez brought up in her comments, which is this exclusion due to the lack of access entirely. Often you have people who are never on the internet. The commissioner mentioned in his comments that 300 million people don't have access to the internet. And so this really brings out the question of what is a digital first approach, which all of our services, public and private, are leaning towards. What does that mean for a marginal person? And this opens up questions both for their data protection and their data quality. What I mean is if there is a gap in the data of a person or a misrepresentation or inaccurate data about them, how does a data protection commissioner deal with that? What should be their role in ensuring that the data quality for a person who does not access the internet directly is protected? But I think the wider question is that beyond data protection, what are the data governance questions that arise, especially when government systems are more and more digital, private systems are more and more digital and interconnected? And on this one, I suppose I have a question back to this audience and to the commissioner as well, is that where do we see the role of data protection regulators in the future for larger data governance issues that will arise alongside privacy as more and more public digital infrastructure systems are built, often interlinking or interoperable with each other within a country, but also internationally, as we are seeing, for instance, with COVID passports, right? Where you want to have country systems talking to each other. And here, I think privacy regulators will play an important role alongside other parts of government, both nationally and internationally, to understand what is their mandate and how can you protect individuals in these kinds of interoperable systems so that their pre-existing disempowerment or vulnerabilities are not exploited and they are in fact overcome rather than being dialed up in such an environment. So I've touched on 3 or 4 points there: marginalization at the boundary itself of a digital system, marginalization in relation to inside a digital system, and then broadly what the role of a privacy law itself, a regime, will be in the future, alongside other data governance laws. But thank you very much for this opportunity, and I'm very curious to hear the rest of this discussion and what we think about these problems that many people around the world are facing.
Muchas gracias.
Thank you very much, Malavika. Very interesting. I would like to underscore the policies that give access to disadvantaged sectors, as, for example, access to financial services that you were saying. But this has to be linked, of course. You cannot first give access to the service and then be concerned because of privacy. You are right. I mean, this has to be something simultaneous, as you were saying. And what becomes very important here is that regulations have to be applied or customized, taking into consideration always the characteristics of each of the sectors and the incorporation to the services, as well as all the data protection needs, given the needs that we have in each of the countries. Now, regarding your question, I would like to add another question, which is the role of the institutions in the future in order to guarantee the protection of personal data. I think that international good practices, for example, Mexico has harmonized, as many other countries like Uruguay, we are now having new regulations in order to harmonize ourselves to the best new practices and then implement them in the different sectors, both in the private and public institutions in the country. But in this second part of the panel, I have been requested to ask a series of questions that had been already planned for this table. And in the same order, you can answer the questions that I will be posing. There are 4 questions. I will read them.
And I'm going to read them all together so that you will be able to take part in them. Well, the first one that was stated by our expert Malvika from India reads as follows: what type of measures in terms of data protection, personal data protection, are necessary to favor the inclusion of vulnerable groups? The second one is, in what way data protection and its appropriate governance can help decrease technological gap and the digital gap as factors that pertain to social disadvantage. The next one, which are the main challenges so that vulnerable population will have the guarantee and protection of their personal information and will not really quit to the rights it has before, and a loyal attitude by the people who are trying to make use of this vulnerability, for instance, assisting governmental projects, operation simulation, financial operation simulation, and illegal. And the last one is from the different organizations. For instance, we can see the global privacy understanding, and which could be the actions that can be developed with the purpose of really being abided by the regulations, especially when it comes to vulnerable personal information. So we would start in the same order, and we will listen to you, ladies and gentlemen. We will give the floor to Gianclaudio.
Yeah, thank you very much. So I think these points are really key. I will reply in a random order because I think there is a fil rouge among these questions. I hope you can all hear me because I was hearing some echo at the beginning, and now I hope you can hear me. If you can write in the chat that you hear me, it would be great. About the first about the point of what can we do to include vulnerable people and to protect vulnerable people in practice, because I think in this first part, great interventions. So I was very, very happy. I learned a lot from all of you, actually. So it was extremely interesting, but I think it was mostly focused on the analysis of the problem. And now I think that the questions are leading us to the proposal of some solutions. I think that the analysis of the problem is still a big question, and I think this discussion has made it even more interesting. But about the solutions, I would just put 2 or 3 things on the table, hoping that the other speakers will eventually collect these points or develop these points. First of all, we need to have a different form of transparency. We don't need just to have more or better transparency. We need to have different transparency about data processing for vulnerable people. And now I am especially addressing vulnerable people under the idea of cognitive vulnerability. So what I call vulnerability within the data processing. There are interesting sources of European Union law that could help. For example, the Clinical Trials Regulation proposes some innovative forms of consent collection of research subjects during clinical and so medical research. They suggest that for some categories of vulnerable people, like for example incapacitated people, minors, people with restriction to their own freedom, etc. There might be some mediators and also a way to collect the real privacy expectation of this person. So I really welcome the point that Malavika was doing. We should focus on a way to understand privacy expectation of vulnerable people without focusing only on the traditional consent. And I know that also Gabriela is a fan of alternative to consent. And then again, so looking for alternative way of transparency, alternative way of collecting data. But something that is not so much investigated, and I think it should be in the future, is participatory design. Even in the European Union AI Act, there is nearly nothing about the participatory design. It's just a recommendation in possible code of conduct. I think we should include vulnerable people, representatives of vulnerable categories, and experts of vulnerabilities in the design and development of data architectures, which is also AI architectures. And I think that it would be key to have these people, these representatives, these experts like psychologists, ethnicists, sociologists, cultural mediators, depending on different vulnerabilities at stake, to have these people to participate to the design. This is a form of ex-ante participation, not just ex post. You know, we said that vulnerable people are often incapable to contest a decision, and are often vulnerable, incapable to exercise their rights after the data processing. Well, we should also maybe change the perspective and involve representatives of vulnerable people in the design itself of the architecture. So before that any right can be exercised, to avoid and mitigate from the outset the risks for vulnerable people, right? So I think that participatory design should be, of course, a way to assist vulnerable people and not just limit their data processing. So I'm connecting now to the double paradox I was mentioning before when I said that vulnerable people have higher concern for their privacy, so higher privacy expectation, but also higher need that their data are processed. Well, this privacy paradox can be solved if they are really part of the design, okay? And I think that the GDPR has also some interesting hints, some interesting inputs about that. I will mention rapidly just two. One is the data subject representative, who is a person that represents data subjects in particular context, but why not, by analogy, using this data subject representative also to represent special categories of data subject. And then another important point in the GDPR is the participation in the data protection impact assessment. And also, in cases of automated decision making, among the rights, we have also the right to say our own opinion, which is different from the right to contest. And I advocate that this, since they are different, the right to contest is ex post. while the right to say my own opinion is ex ante, so be involved in the participatory design. Okay, so this is one possible thing that I really care about. So sorry if I emphasized it a bit too much, but I think it's important to bring the discussion to this. And then a last point is about what institutions can do. This was mentioned several times by our moderator, the commissioner, and also I think it's important to understand what institutions like data protection authorities or governmental institutions can do to protect more vulnerable people. Well, I think we have some examples. Gabriela was mentioning the case of EdTech, in which data protection authorities intervened, for example, in Sweden about this. But I think another important example is guidelines for special categories of people, how to protect children. This is what the UK ICO did several years ago, like 3 years ago. So special guidelines on how to protect specific vulnerable categories. We have something in Europe because we have data protection authorities that have implemented in their own national list of high risk of data processing, also some mentioning of some vulnerable people, but it's just like very superficial at the moment. Then another thing that I think can be done, and this is also to connect to Valeria's speech of before about vulnerability compared to power concentration. Well, I think that authorities, institutions should communicate for a common definition of what is power as the counterpart of vulnerability. She mentioned, let's say, competition law power, so power concentration and political concentration. I think that power concentration is really key. We should define what is power for Facebook, Google, etc., so that we can also more easily define what is vulnerability and how to protect vulnerable people. I will just mention one case and then I will mute, which is a case in Germany last year. The Competition Law Authority has imposed high sanctions on Facebook on a competition law basis just because it was abusing of its power in asking consent to people because to data subject, because Facebook was considered a monopolist and data subjects were considered, of course, vulnerable regarding to Facebook. So I think institutions could work also at power concentration and vulnerability. This is another part of vulnerability. This is not the traditional vulnerability that we think, but it would be very important to help us to understand what are the areas of vulnerability. So basically, these are the point that I wanted to address. And of course, positive action would be, of course, better access to internet and better access to digital services. But it has already been said so far, so I will not repeat myself. Thank you.
Muchas gracias. Bueno, pues como totalmente de acuerdo en que...
Thank you very much, and I agree on the following. First of all, we have to make a diagnosis to describe problems. And here, with the questions we have here, we need to see what are the possible solutions, participative design through mediators in order to create a protection expectation where people through representatives or they themselves can really bring about expectations. In this regard, I think this is an important statement that would later take us to this and allow us to see where important institutions can play a fundamental role. Well, I will give the floor to Dr. Valeria Milanés. Gracias.
I'd like to, sorry, I'm hearing myself. I am waiting to the echo stopped. I'd like to say that, sorry, I'm trying the echo disappeared because it's quite distracting. Now, better. Thank you so much. So I take three of the three questions, and I will try to provide input, because listening to my colleagues in the panel and to the commissioner, I have to say that I agree with most that is being said. I am trying to add some nuances that I know that are happening in my region. When I was talking about concentration of power, I'm not only referring to the big tech, but also to traditional family companies that have the monopoly of the telecommunications and etc. A lot of time in the region, and provoke are part of this kind of perpetual inequity. The report of the UN is quite illustrative in this sense. I really recommend this lecture. So regarding to the questions, I would say that in terms of data protection policies, when we talk about people who live in poverty and is marginalized, it's necessary to have a view of the intersectionality of this kind of vulnerable situation, because most of the time it's not only about the amount of money or not money that that person or the family is receiving. There are also structural features that are there, that are part of the reality that prolongs them at some way. So I would take what one colleague said about the data protection as an inclusive tool, because it would be really sad that we try to protect privacy and data protection, but not thinking about inclusiveness and the possibility that this legislation and the measures that are taken, and I also mentioned again about competition, about concentration, we should pay attention to that also, because it is directly linked. These are tools that could promote inclusiveness. So in this sense, I would say that if we take into account the different features that affect this marginalized position, it would be better, the more effective the measures taken in place. And it's necessary not only by the public sector, but also by the private sector, that it maybe can try to achieve and to take into account these issues in particular. Another thing that it was shared in the question is that if we, and this is something that we struggle with, and I'm pretty sure that is part of much of the world, most in the global south, the lack of diagnosis. Sometimes we don't have proper data to understand what is happening, what are the effects, what are the consequences that different kind of people in vulnerable situation is facing. And another thing, taking another question, what the international organisms like the Global Privacy Assembly and similar to that can do, I think that is pretty much, because taking again the case that I shared with you previously, related to what is happening in Latin America with concentration, the established of laws regarding competition were a consequence of the OECD intervention. So this should be taken as an opportunity. And again, I'm pretty aware that the Global Privacy Assembly is trying to push these dialogues between the competition authorities and the data protection authorities. They should think together how to tackle this, because in countries like the ones that I said, that like the ones that are part of my region, where the power, political and economical power, is so strong in hands of the private sector, with the consequences that we all know and that are registered and are part of a lot of studies. I also want to highlight that we are now seeing this kind of promotion for free trade agreements. If the free trade agreements that our countries are signing have no proper protections, have no proper provisions, the direct affected and the worst affected would be in economical terms in general, but also related to their own data, would be the people that lives in poverty and in marginalized situation. It's a kind of direct effect. So I think that there are a lot of research to do to properly understand how all of this work, how all the links on this work, and encourage the GPA to strengthen these dialogues, to promote them, and to ask their members to introduce these dialogues with different authorities, because this it's necessary that multiple parts dialogue. So thank you so much.
Muchas gracias, doctora Milanés.
Thank you very much, Valeria Milanés. I would like to give the floor directly to Ms. Montes. Would you be so kind as to take the floor?
Thank you, Commissioner. I would like to pick upon some of the points that my colleagues have reflected on, and I would like to make this reflection from, again, the financial sector. And I think this is important because whatever privacy or data protection policies, I do think that we need to look at them from this sectorial approach, because it might have different consequences and it might have different implications. So I'm just going to pick up on two or three of these elements. First of all, going back to the discussion on consent, and I know this is a very hot debate around the world. I do think that from the work that we have been doing on open banking and open finance and the need to provide consent, I cannot think of another alternative. We might think about the terminology or how do we call it or how we provide it, but I don't think that we can't avoid looking at the access to this data, which should be under a permissioned environment. So how do you call this permission? That's something that we can discuss. Maybe it entails moving away from the traditional kind of consent forms and that's another story that we have also extensively studied and researched on these new ways or new mechanism providing consent in a more practical and dynamic way, providing more control over data subjects, and not only to provide the consent but also to revoke it and to look at all the history of the different types of data controllers and processors that have been accessing this information and for what purposes. Of course, this is not the only legal or lawful basis for data processing. This has to be surrounded by another number of protections and safeguards. On the discussion that I hear from my colleagues, I see it's too much centered on, except Malabika is too much centered on the European Union and the context there, and where we operate at the World Bank. There are many countries that are still lagging a robust legal framework on data protection. So if this is the case, how do we go around it? And we have been very carefully including several institutions and several provisions under financial sector regulation or laws that deal with data protection and privacy. So there are ways to go around this type of protection for a specific sector. The other aspect that for us is specifically important is the automated decision making. And again, through the work that we've done on alternative data, we have been looking at this from this unfair discrimination. And one of the things that we have seen is that all these scoring models were based on historical data. And this historical data, unfortunately, did not take into consideration all the different types of vulnerable population. On the other hand, it marginalized them and discriminate them unfairly. So moving away from historic discrimination, this is something that I would say is a good measure. We have included this in the document. I will make all these documents available for you if you want them. But this is one of the measures that we are suggesting. No, unfortunately, the data is what it is. So we need to build more robust data, calibrate again the scoring models and the automated decision models, because they have an impact on the lives of these groups of people. I also want to reflect on the different types of vulnerable people. How do we define these segments? At the financial sector, it is not that relevant, or we don't really look into the minors because they are not typically subjects of the financial services offered. But we do take a look at women, which in the European Union, they might not be an issue. But in some countries, we also need to look at the contextual and the cultural context of that, where women are not even able to participate in the social life. So how are they going to be able to participate or request any type of protection from a data protection perspective? So the cultural context is also something that I think it's extremely relevant that we take into consideration. The same goes with migrants and how they are perceived and how the rights are obtained or perceived in the countries that of destination or the countries that they reside. And then in terms of what are the role of authorities? And I've seen some of my colleagues discussing the linkages between the competition authorities and the data protection authorities. I do think that in the times that we are living, there is a need to coordinate better at domestic level between different authorities. Indeed, the data protection authorities, of course. Competition authorities in moving forward the financial sector agenda. Of course, financial sector authorities need to be involved, and there are many questions that the data protection authorities might not have sufficient information about. So this coordination and this dialogue with them might help in moving forward a more balanced agenda, as well as some dialogue with the private sector, both service providers, third parties that are providing additional complementary service, that they might be able to participate in the discussion on what type of information is needed, so that we apply principles in a balanced manner. I'm referring here to the data minimization, the purpose specification, and so forth. And how do we bring these principles into the different sectors together? So from my side, this would be these reflections. And finally, when we discuss literacy, let's call data protection literacy, I think it's important that we do it through means and ways that provides them some kind of teachable moments for each of these types of segments, which might be very different if we are discussing about minors, or we're discussing women, or we are talking about migrants, or we are talking about indigenous people, or others that have any kind of a handicap situation that allows them to understand things in different ways. So being a bit more flexible in the way we provide both transparency and remedies and consumer protection or data protection rights to these groups, I think it's something that it would allow and provide much more support to this type of groups. So I leave it there for reflection of others. Thank you.
Thank you so much. And we have 8 minutes left or 18, it all depends because we start at 10 minutes late. I don't know if it's 8 or 18, but I would like to give the floor to Malavika. You have the floor now, Malavika.
In which I want to try and answer your questions about principles. How do we get some principles in favor of vulnerable groups? To that question, I think the important thing to think about is to switch the way we think as policymakers from the provider perspective, the data flow perspective, to the user journey. The fact of the matter is that the user journey in digital services has changed dramatically in the last 15, 20 years since the iPhone, really. And now users don't go through a process where they give their data, they give consent, the data is then processed, it's then stored. It's all happening real time. It's very intuitive. And often users are not able to make a distinction between when they sign up for the service and what service they are even using. To give you an example, these days many people get preloaded phones, right? A phone on which there are preloaded apps, which they don't need to create an account. And they may not then know the distinction between the phone, the app, the internet, the telecoms provider, and so on. And in this context, I think it is unfair to create these concepts of consent, for instance, because asking the user for consent to their financial data is fairly meaningless at that stage, because all they want to do is they are primed to access a service and they are just clicking the buttons. So I think what the law needs to do, and what policymakers I would love to see do, is undertake extensive consultation with user groups, but actually go through the user journey and just apply our timeless data protection principles to this new user journey, and think in a world that there are none of these steps, and all of these services are intermingled and bundled and offered in one screen to the user. Where actually can we do privacy by default? Where can we do data protection by infrastructure, and not make it an individual contract between the financial services provider, the browser window, the phone, the app, and each of those contracts taking data from the user? It's simply not a sustainable model anymore. I also think the other reason that we need to look at the user journey is context. Again, to give you an example, when in India we asked people, what information do you get to give a loan? Do you give to get a loan? And they said, phone number, bank account address, details, and so on. Many people then did not know that banks then share on the information, or even that they retain the information. So the mental model, the fact that information is retained, it is then passed on to a telecom provider. All of these things users are not even comprehending at this stage. It's not because they are illiterate, or it's not because they are have cognitive limitations. These studies have also taken place in Stanford University with very advanced students and so on. It's just the nature of the digital interface today. So I think there's importance to understand the user journey for data protection principles, to understand the user journey for context, and to also understand the social realities we've talked about, where gender, class, caste, and so on play out. To your second question, very quickly, in terms of the role of the authorities, I wanted to say that there are 3 levels at which I think this is important. One is, I think the data protection authorities have an important role in teaching other regulators. So again, I'll go to finance because that's my field. In India, for instance, we have a requirement now in digital financial services that every time you do a transaction, you get a one-time passcode. This was mandated because of data security and data privacy reasons, that there's no fraud. However, what happens is, in the context of a shared access and use situation, that means every transaction of a child in the family, an older person, a woman, anybody else, has often in a shared phone has to be authenticated by the male head of household. And often this compromises the financial privacy, especially of women who often have secret spousal spends, right? And so if you go completely into digital, I think we need to think very carefully about when you go digital, how does that intersect with privacy, and what are the redundancies and other features you need to build in? Like, do you need to build in a back channel where you actually keep a human female agent who is running your banking correspondent, so that where a woman wants to exercise her privacy and not send her one-time passcode to the family phone to do a transaction, she has the agency to do so. It does take capacity, of course, but I think it's important. The other two ways that authorities need to intersect. So for these kinds of rules, I think it's important for a privacy authority to be talking to a sectoral authority, even in the administrative rule making, not just at the legal level. Of course, surveillance and competition, Valeria has already spoken about, but I do think more and more antitrust and data protection authorities need to work together horizontally and set the rules so that sectoral authorities can then do what they need to do. And lastly, very quickly, and I'm rushing, I did want to say that consumer redress we haven't talked about in this conversation. I know there are some great app providers in India who are building IVRS phone solutions where people can complain. Often when people have a privacy harm or a fraud, for instance, they don't know where to go. And it should be as easy as it is to interact on a digital platform to also make a complaint. And I often think the consumer redress part of things is always hidden away. You have to, often especially in India, you have to make a written complaint. You have to go somewhere and file that complaint or write an email, which is not easy for people anyway who are not digitally using an English keypad, for instance. So I think thinking cleverly about how can we give quick complaints and how we can use human front ends such as kiosks, telecom service providers, people who sell you your SIM card, how can we use them to get user complaints so that we can better understand where vulnerable people are having both difficulty with their privacy as well as difficulty with digital services, I think is an important thing to talk about in terms of understanding the challenges of the vulnerable in each of our societies. And I should note on that context, none of us here, or at least I definitely can't claim to be very vulnerable. So already I hope that in future of these discussions, maybe we can have another side panel where we actually bring in some marginal users and have a workshop with them as well. Thank you so much for this opportunity.
Thank you, Malavika. Thank you very much. And I would like to give the floor now to Gabriela, who was the last member of this panel, and then we close this table. If you are so kind as to make your comments now, Gabriela.
Thank you so much, Commissioner. It's such an honor for me to be able to close this panel with a couple of remarks. I absolutely agree with all of my colleague panelists. They made some excellent points, and I would particularly like to emphasize a couple of the ideas that were shared and add to them. So, for example, I absolutely agree with Frede that we need to look further than the European Union law, of course. And this is why I have been paying a lot of attention in recent months to fairness provisions in different data protection laws around the world. And one of the reasons why I kept pushing for this concept of fairness to be more and more understood and applied is also because I see manifestations of this concept in laws that are currently being adopted or updated around the world. Just to give you a couple of examples, if we look at the very recent law in Brazil, which entered into force about a year ago, we have a principle of good faith. They're saying that data processing activities must observe good faith and principles such as non-discrimination, impossibility of processing data for discriminatory, unlawful, or abusive purposes, which of course links my thought to fairness as well. I'm looking in the South Korean Personal Information Protection Act, where in Article 3 we have mentioning of how the controller should collect personal information lawfully and fairly to the minimum extent necessary for the purposes for the collection. In South Africa, in this South African law in Popia, under the principles of lawfulness of processing in Section 9, we have a reference to processing that's done lawfully and in a reasonable manner that does not infringe the privacy of the data subject. So we are seeing some manifestation of non-discrimination principles, reasonableness principles, fairness in most of the data protection laws that are being passed around the world. And this is where I think there is a space that data protection authorities and privacy regulators can start occupying more and more, and can have a role in unpacking what this type of provisions mean in terms of bringing up the marginalized populations, and in terms of ensuring that how personal data of these populations is used in a way that provides and promotes inclusiveness. So with this comment, I will end now, because I know that we already ran a bit over the time that was scheduled for the panel. And I do hope that some of the ideas that we shared will help data protection authorities to step up the inclusiveness game. Thank you so much, Commissioner, and thanks to my fellow panelists.
Bueno, tomando en consideración la
Taking into consideration all the information that we have discussed here in this session, where we discuss the most relevant points related to inclusive policies, linking poverty and marginalization sectors in the protection of personal data, and the perspective on human beings and human rights, we can conclude that poverty and marginalization that have existed, not all the people do not allow all the people to have the same benefits and the same protection of their personal data, and therefore we have to pay attention and to protect the most vulnerable sectors, because they are an easy target, or maybe an easy target. On the one hand, we have to contemplate those who do not have access to technological tools, and on the other, those who do have access, but they don't know how to use them correctly.
Sí debemos considerar también la calidad.
In this way, we need to consider the quality of the use based upon the differences of several users, mostly underprivileged people. This meeting has allowed us to see which are the main policies that can be used in order to take into account the basic elements and look for the best postures in order to eradicate all this and give relevance to the objective of improving and guaranteeing personal data protection in vulnerable groups. In such a way, we are wrapping up this meeting, thanking the participation of the great speakers we have had, and I am sure that the topics discussed here will really help us to have a better general perspective before the electronic dynamism. Finally, I invite you to follow us in the next meetings. Have a beautiful evening. And, well, I think that good morning to the people who are in a different time schedule. Thank you very much.